literature review of this wiki includes the following. Susan Dickey, an RN, in a 2002 article published in the Journal of School of Nursing, advises readers that the Family Educational Rights of the Privacy Act in 1974, hereafter referred to as FERPA, protects the privacy of students and their parents by restricting access to school records, and is the key legal standard for school nurses and other personnel to follow. She additionally advises overriding the federal regulations imposed by the Health Insurance Portability and Accountability Act, hereafter referred to as HIPAA, stating that its final version specifically excluded schools from the requirements of HIPAA. In November 2008, the U.S. Department of Education and the U.S. Department of Health and Human Services issued a document titled Joint Guidance on the Application of the Family Education Rights of the Privacy Act, FERPA, and the HIPAA to student health records in order to clarify the requirements of HIPAA upon schools. Provided therein is a statement that when a school provides health care to students in the normal courses of business, such as through a health clinic, it is also considered a health care provider as defined by HIPAA. This document was circulated in the website of the National School Boards Association following the Virginia Tech school shootings in April of 2007. While treatment records of the students are excluded from HIPAA coverage, as are education records, compliance could still be mandated if the school provides health care as above. The basic premise of disclosure of medical information is based on HIPAA and FERPA, which both state that parents of minors are entitled to have their written authorization obtained before releasing any treatment records and educational records to third parties. The American Academy of Pediatrics, through its Committee of Bioethics, felt the need to restate its position on informed consent, stating that the doctrine of informed consent reminds us to respect persons by fully and accurately providing information relevant to exercising their decision-making rights. A reanalysis of informed consents lead to the identification of important limitations and problems in its application. Two additional concepts are needed: parental permission and patient assent. The American Academy of Pediatrics believes that in most cases, physicians have an ethical and legal obligation to obtain parental permission to undertake recommended medical interventions. It is important to recognize that a patient's permission to undertake medical treatment is no less important than the patient's right to allow dissemination of the medical records and that detail such treatment. The Committee on Professional Standards, under direction of the Board of Professional Affairs, is the government committee charged by the American Psychological Association to evaluate and monitor its standards and its members' compliance therewithin. On July 1988, the review of the case was published in the association casebook as Case 1. The children of a separated but still married couple had been taken by one parent to a family therapist for evaluation. That psychologist recognized the illegality in doing psychological evaluations on minor children without the knowledge of permission and a custodial parent. The Committee of Professional Standards felt that without a specific request from the court or a written agreement from both parents' attorneys, the psychologists in this case overstepped bounds by making specific recommendations in favor of one parent over the other. The committee further stated that the civil rights of people involved in a custody dispute must be protected. Later, in June of 1989, casebook publication, a correction was issued to the above case regarding the statement. The psychologist recognized the illegality of doing psychological evaluations on minor children without the knowledge and permission of the custodial parent. The Committee of Professional Standards stated that upon review, it appears that the statement was overbroad. The legality of the evaluating minor children on behalf of the non-custodial parents whose parental rights have not been terminated varies from state to state. Advice is given to thoroughly research state law and regulations prior to embarking upon evaluation and the behest of a non-custodial parent. The important issue delineated in this case and its correction is that a custodial does not mean that neither parent has the rights to control the child. Until such time, a parent's rights have been terminated. Both parents of the child have the rights of control, and that must be respected.